Well, basically, if the rule is upheld, they're going to have to either decide whether to convert their employees to hourly status and pay them overtime for any hours they work above 40 in a given week, or they're going to have to increase their employees' pay to meet these new thresholds. The one thing I would stress, the most important thing is businesses should prepare now for the rule to take effect and act as if it is going to take effect. That's the wisest strategy to pursue at this point.
The Small Business Rundown is the official podcast of the National Federation of Independent Business, the member-driven voice of small business. NFIB and our members advocate to keep America's small businesses strong and independent in Washington, D.C., all 50 states, and the nation's courts.
Welcome to the Small Business Rundown, a biweekly podcast with information on independent businesses' victories and challenges in Washington, D.C. and state capitals. I'm Adam Temple, NFIB Senior Vice President of Advocacy. The Department of Labor released a new overtime rule that takes effect July 1st. Here to discuss the details of the rule and answer questions on wage and hour compliance are NFIB Small Business Legal Center Executive Director Beth Milito and Senior Attorney Rob Smith. Beth and Rob, thanks for coming back.
Thanks for having us, Adam.
Yeah, thanks, Adam.
First, let's answer some common questions the Legal Center receives about wage and hour issues. Beth, I understand your team frequently receives questions about worker classification, meaning employees versus independent contractors. So how can small business owners avoid a mistake in classification?
Great question, Adam, and I'm going to start by sharing an answer I heard from a friend who practices wage and hour law, and he said, when in doubt, put the worker on your payroll.
Okay.
So make them a W-2 employee if there's any question as to whether or not they're an independent contractor or an employee, because it is a really confusing area of law. Mm-hmm. And the other thing I should say, too, at the outset, because this applies to all wage and hour issues, is employers need to be aware of federal and state law, because as you know, Adam, states are pretty active in the labor and employment arena now, and many state laws and even some municipal laws now are much stricter for employers. So you always need to follow the law that provides the employee with greater rights or more pay there. So, and this is true in the area of independent contractor too. Many states have pretty strict laws on who is an employee versus an independent contractor. NFIB has a great handbook on independent contractor classification that's available on our website, nfib.com. So business owners can take a look at that too.
And what about designating a role as salaried versus hourly? What should small business owners keep in mind as they make those kinds of decisions? And
this is another area where I'll share a tip from a wage and hour attorney. When in doubt, make the employee an hourly employee. Okay. So in other words, payroll records are very important for hourly employees. So the old proverbial punch a time clock, again, that's always the safer course because then you've got good records. If you're classifying an employee as exempt, don't rely on title only. So calling them an executive assistant or an administrator doesn't necessarily mean that they are automatically an exempt employee. You need to look at the amount of salary, the duties they're performing, and whether they're being paid on a salary basis.
And Beth, we are in the throes of summer, and that means a lot of small businesses are taking on seasonal help, and that includes teenagers. What are some tips or guidelines that small businesses should take into account when hiring teenagers specifically?
This is an area where businesses really need to make sure they're in compliance because the Federal Department of Labor and state labor departments are really cracking down on child labor rules. Mm-hmm. So businesses need to be very careful about following these rules when it comes to teen workers. So by and large, for the most part, you cannot employ a teenager who is under 14. If the teenager is 14 or 15 years old, then there are limitations on the type of work they can perform. They can't perform any sort of hazardous work, transportation. They actually can't work under Department of Labor rules on ladders or scaffolds, believe it or not. That's considered hazardous work there. So no, I said no transportation, but that probably makes sense because most areas of the country, I think 14, 15-year-olds aren't driving anyway. But just be aware of these rules because there has been crackdown by labor departments.
And you mentioned earlier punching the clock. That is one way to keep track of hours. What are tips that you've got for small business owners can effectively keep time records for their employees?
And I would say over-document is the way to go, too. Another handbook that NFIB has available is the Wage and Hour Handbook. And also on the Department of Labor's website, too, there's a great checklist for all the record keeping that you need to keep for your employees. But more is always better. Keep it at least for 3 years or, as long as the employee is working for you, too, there. But check out what's on the Department of Labor website.
Rob, shifting over to the topic of the Department of Labor's new overtime rule as it stands now, will you provide an overview of the new rule and what that means for small businesses?
Sure. Thanks, Adam. So I guess the first thing I should mention is that we are recording this podcast at the end of June. So things may change by the time our listeners tune in and hear this in regards to the court cases that are out there and whether the rule takes effect. So that is the first thing to keep in mind. So just an overview of the rule. What it does is it increases the salary thresholds for the salary level test of the executive, administrative, and professional employee exemption from overtime pay. Now, there's a lot in there, so let me back up to 30,000 feet and kind of give an overview. So the Fair Labor Standards Act, the FLSA, requires that businesses pay their employees a certain minimum wage and overtime pay. But it includes many exemptions that I'm sure some of our listeners are aware of. The most popular of these is the executive, administrative, and professional exemption, or they may know it as the EAP or white collar exemption. That's a commonly used exemption. So any business utilizing this exemption for an employee has to show three things. One, that the employee engages in certain duties. Two, that the employee is paid on a salary basis. And three, that they're paid a certain salary, which is the salary level test. So what the new rule does is it increases the thresholds that an employee has to be paid under that salary level test. So switching gears to the new rule and what it does exactly, currently that threshold is $35,000 and change per year, which equates to $684 per week. The new rule increases that in three phases. The first phase takes effect on July 1st of this year, 2024, and it increases the threshold to $43,888 per year, which is $844 per week. Phase 2 takes effect on January 1st, 2025, and increases the threshold again, this time to $58,656 per year, or $1,128 per week. So grand total from where we are at currently, this is a 65% increase in the threshold from June 2024 to January 2025. Now, I mentioned that there's three phases to the new rule. The third phase takes effect in July of 2027. And what this does is it doesn't increase the threshold to a new numeric amount. It automatically increases the thresholds every 3 years based on the current wage data. And most importantly, it does this without any opportunity for small businesses or NFIB to weigh in on whether that is a good increase or whether the chosen number is too high or appropriate. So what does this mean for small businesses? Well, basically, if the rule is upheld, they're going to have to either decide whether to convert their employees to hourly status and pay them overtime for any hours they work above 40 in a given week, or they're going to have to increase their employees' pay to meet these new thresholds. The one thing I would stress, the most important thing is businesses should prepare now for the rule to take effect and act as if it is going to take effect. That's the wisest strategy to pursue at this point.
So it should go without saying this is hugely problematic for small businesses. How is NFIB fighting the new rule?
Yeah, big problem. So we're fighting it on multiple fronts, actually. We've filed a lawsuit against the Department of Labor, and we're asking the court to block the rule. And we're cautiously optimistic. There is some background about a similar rule being struck down by that same court in 2017. And there were features of the rule that was struck down in 2016 that are similar to the Biden administration's rule. So we're hopeful that we'll receive a good outcome from that court. But the second way is we've also filed a friend of the court brief in a second case that's challenging this rule filed by the state of Texas. And the court actually just held a hearing on the state of Texas's lawsuit yesterday, which would be June 24th, and whether the court should block the rule from taking effect while it considers the full merits of the case. So what that means is we may get some relief here soon, depending on whether the court thinks it's appropriate to block the rule before the first phase kicks in on July 1st.
Rob, Beth, before we go, is there anything else you'd like to add?
Adam, I would just say that folks can check out the webinar NFIB had on June 5th that provides more information where Rob and I did a deeper dive into the new overtime rule. And again, that is on our website. Anything you want to add, Rob?
Sure. I would just add that anyone that has questions on the new rule or wants to know the current status of the rule, please reach out to us at info@nfib.org. Beth and I are happy to answer any questions you have or provide status updates.
Thanks, Rob. Thanks, Beth.
Thanks, Adam.
Thank you.
Our next episode premieres on July 25th, and if you have small business questions or topics you'd like to hear about, please send us an email at podcast@nfib.org. And now I want to thank you, the listeners, for joining us on today's Small Business Rundown. We'll be back every 2 weeks bringing you news and analysis from Washington, D.C. and state capitals so that you, whether you're a small business owner or a supporter of one, can continue to blaze a trail.
The Small Business Rundown is brought to you by NFIB, the voice of small business. You can find us at nfib.com and on Twitter, Facebook, Instagram, and LinkedIn.